Summer is in full swing, and whether you're heading to the beach, the mountains, or just putting on extra miles around town, make sure your vehicle's ready. Stop by Valvoline Instant Oil Change for a 15-minute drive-through oil change. Stay in your vehicle while trusted technicians change your oil, check your tires, lights, and essential fluids. No appointment needed. Valvoline Instant Oil Change, the easy choice for summer driving. Coupons at BayAreaOilChange.com.
Hey, it's your girl Titi Torres, and let me tell you a little bit about myself. I'm a mother, a wife, plus a 20-year multimedia executive and personality, and your host of Tap In with Titi, the podcast, where the culture speaks loud and clear. I'm having conversations with your favorite artists, rising stars, movers and shakers, from the streets to the boardrooms, from healing to hustle. New episodes every week on the Odyssey Creators Live, Spotify, Apple Podcasts, and wherever you get your audio. So tap in with me, Titi. What are you waiting for?
Welcome back. Today we have a very special guest. I'm very excited to announce that we have Lauren Johnson today on our show. And Lauren Johnson is a partner at the boutique law firm Rabon Kammerer Johnson in West Palm Beach, Florida, representing businesses and individuals in a wide variety of complex business litigation cases and whistleblower matters involving fraud against the government, aka Qui Tam. Prior to joining her firm, Lauren worked as a law clerk for Justice Labarga of the Florida Supreme Court and for U.S. Magistrate Judge Matthewman of the U.S. District Court for the Southern District of Florida. Lauren has been named Florida's Rising Star by Super Lawyers since 2020. She received the Leader in the Law Award from the Florida Association for Women Lawyers in 2024, and she has been recognized as Best Lawyers in America for both commercial litigation and Qui Tam law since 2024. Welcome to our show. Thank you for joining us.
Thank you for having me.
I'm so excited. Yeah.
This is exciting because we know you personally also. So other than maybe one or two guests we've had in the past, like we have a personal relationship with you also, which is really cool. So it's fun to bring.
You just came to my wedding.
I did just come to your wedding. That's right.
Yeah.
Pretty
cool.
That's cool. And so it's very exciting to have you on the show. Thank you for coming.
I'm really excited to be here. I didn't realize I had so many stories until I started thinking about it.
Yeah.
That's good. That's why we have you.
Yeah. And I mentioned this before the podcast, but like you literally are like a unicorn to me, at least as even a practitioner, like in what you do in the industry. And so like, I just am excited to kind of get into like talking about it because we are, every setting I see you in, it's always like related to fall, which by the way, Lauren is current fall president, Florida Association of Women Lawyers, which is a really cool thing and wasn't a part of your intro. So she has way more about her that we haven't even gotten into, but I'm really excited to just like learn more about what you do like every day because it's stuff that I feel like is like kind of glamorized on TV in parts of law that like we really don't know what the behind the scenes looks like. Mm-hmm. So,
you know what? Before we get started, one other thing that was left out of the intro that I find to be very important is a shout out to two individuals. First, Tom, your husband. Second, Ollie, your dog. Very important for me to shout out both of those people. I don't know if either of them will be listening, but I want to make sure that they get their own shout outs because they are important.
Yeah.
They will both appreciate that.
Good.
That's hilarious. I thought you were going to say something about Jen.
No.
He's going to mention Jen right now.
I do love my wife as well.
Yeah, because you were saying, no. The reason why I said that is because you said that we didn't have previous personal connections with other guests. And I was like, well, we had your wife on the show. So.
Well, no, I didn't mean, yes. With the exception of her, I didn't mean she doesn't count because she's literally like
she's literally
a part
your
of
other
me.
half.
Right. Yeah,
exactly,
she's my other half. So
anyways, so talking about what you do and, before we get into like whistleblowers and everything, you did have some experience kind of like seeing behind the scenes of, the bench and more like the kind of, I don't want to say the most important, but like, I mean, it doesn't get higher than the Supreme Court. Mm-hmm. So I guess like before we get into like what you do and how it even ties into what you do now, like what experience did you gather that you found like most invaluable? Like what did you think was the best thing that you got out of working with judges?
From the clerkships, I got different things, I think, from both of them. Working at the Supreme Court, it's the appellate level, so it's not like you have a trial or people every day in the courthouse in front of the judges, it's a little bit isolating because all they have is oral argument once a month, and that's about it. So during that time it was right out of law school that I went and I did that clerkship. And so that was really, refining my writing skills, learning how the judges look at cases and analyze them, how they make their decisions, and just really seeing how kind of the process works of the court logistically, and understanding that and getting that base for going into practice then as a lawyer after that was really important to me. And I think every law student should probably do a clerkship after law school, because it's just really, it's such a great experience to see the courtroom from that perspective and get that kind of like insider knowledge, if you will.
Yeah.
But then with Judge Matthewman, that clerkship, he's a magistrate judge, a U.S. magistrate judge, which means that he does all the pretrial matters in the federal court. And so parties can consent to him as the judge for the entire trial, but for the most part, he does the pretrial matters. So he does a lot of the discovery. He does the motions for summary judgment. Sometimes they'll get referred to him. Sometimes he'll do the motions to dismiss. Sometimes he'll do motions for attorney's fees. So that clerkship was really more so really learning the law and how it's applied, because law school is so, I mean, as soon as you leave, everything leaves your brain.
Literally.
Yeah, that's right.
You don't remember anything.
No, totally.
And you just like kind of know like a very cursory idea of areas of law, but you really don't know how it like kind of plays out.
Mm-hmm.
And you got exposure to really, I don't know, was it every type of case or like a variety of cases? It wasn't just like a specific niche.
Yeah. It was every type of case. I mean, at the federal court, that was every type of case. It was civil. He had criminal cases, but he mostly just did like first appearances, the pretrial stuff, the detention hearings, things like that. He didn't handle the rest of those cases. But at the Supreme Court, at that court, you have death penalty cases. And so if a criminal defendant is sentenced to death and appeals it, it gets immediately appealed to the Supreme Court. And they hear it. And if you get sentenced to death, you have multiple different avenues of appeal, different chances. So every time those death penalty cases, that there's anything in them, the Supreme Court hears that. And so that was like the criminal exposure that I got of criminal law. But besides that, like there was constitutional issues there, constitutional challenges, and then just, every civil type of case that you could think of. There was, fraud, there was breach of contract, there was foreclosure, there was employment matters, there was Social Security appeals, like there was everything.
You literally saw everything.
Yeah.
Helped give you a little bit of flavor for the law as a whole. So that way, when you want to start navigating to your own specific area, which you did, I mean, that there really is no better way to do that for somebody that is trying to see what is out there before they jump into the actual practice of law.
Yeah.
Yeah, that's pretty smart.
That's exactly what it did. It really helped me to narrow down what area I wanted to go into, and especially what areas I did not want to go into.
Yeah, true.
That I saw, and I just knew I wouldn't be able to handle something like that. So it really was great for that, and definitely recommend it for any law
How'd you
student.
get the opportunity to become, I mean, like, I know you're saying like I would recommend it to every law student, but obviously it's like a prestigious thing to get. It's not an easy position to get. What would you, if we have law students listening, because I know we do, what would you tell them about like what, if they're interested in kind of following in that path, what to work on in law school to get that opportunity?
So a lot of those clerkships are posted on the websites of the courts themselves. So the Supreme Court the Florida Supreme Court website, they'll post and advertise for open positions. And those positions are, they're filled way ahead of time. So it could be 2-3 years out that they say, in 2029, Justice Coriel is going to be having an open position for a temporary term law clerk. And so the justices of the Florida Supreme Court, they have term law clerks and they have career law clerks. And the term ones, they're usually 1 or 2 years. And so those are the ones that rotate, and those will be usually law students that have recently graduated, whereas the career law clerks will be more experienced, older attorneys who know and have the institutional knowledge where they can like pick up right away a case and work on it immediately so that the justices aren't, kind of having to like train people every single time a new clerk comes in.
Wow. That's so crazy. I would have never guessed that they have kind of like, I don't know, I wouldn't call it a waiting list, but.
Yeah, it can be a while. So, I mean, I would say
it's a long application process.
Yeah.
I would say look ahead of time for sure. And some of them are different. Some of them hire only 1 year out. Some of them it's longer. Some of them it's shorter. So all the judges are different. And same with the federal court judges. For federal court, there's a website called Oscar where you go on there and that's where the clerkship positions are posted. And, you could just see what judges are hiring for what clerk positions. Or a lot of them do internships too. You can do an internship while you're in law school.
Yeah.
Another good way to kind of get in if you wanted to would be to try to do an externship, like wherever you are in law school. I went to University of Florida. So in Gainesville, they had an externship where you could intern for a judge in Gainesville and get school credit, but you're still getting that, like experience with the judge. You're in the courtroom. You're getting the same kind of perspective if you were as a clerk after law school.
Yeah. Okay. And I know you said it was like kind of isolating. Like, why do you say that? Because I mean, for me, when you say that, I'm just thinking, is it because you're the only clerk there? Is it because, like, you're not working with other attorneys? Like, what is it that made you feel so isolated during that?
That was only for the appellate court. And I only say that because they're not seeing trials every single day. And they're not having attorneys come, like kind of like a rotating door the way that a trial judge is seeing new parties, new cases every single day coming in front of them. It wasn't isolating for me personally because, Justice Labarga alone had 2 other clerks. So every justice had 3 clerks.
Okay.
And, we all had like a group and we would hang out together and go to lunch and stuff and have a great time. So not personally, but I would just say that if you're kind of a people person and you want to see people every single day in front of you and hear different stories every day, then that appellate court is not what you're going to get there.
Yeah, that makes sense. Mm-hmm. So like when it comes to like attorneys coming in every day, and we were kind of talking about this before we started recording, but like just like interacting with judges and seeing how certain attorneys do, and I'm sure you probably saw some of the same lawyers over and over, but like what did you notice that like made the judges kind of, I don't want to say like pleased because, whatever, but like what was like in terms of preparation and like all the things that we kind of talk about for like attorneys' ethics and things like that. But aside from that, like what are the things that you saw that would make attorneys like most prepared to handle a case before a court?
Besides preparation and knowing your case, it's trying to keep it simple. I mean, I know for a jury, the rule is, keep it simple, explain it in the most basic way possible. But like even the judges want that, like they don't want a bunch of fluff when you, file motions or make the arguments. They don't want a bunch of fluff where you're trying to give them this whole background about why the other side is such a horrible person or, these other terrible things that they did to like color the way that the judge is going to look at the other party. They don't want to hear all of that. They don't care. They just want to get down to the brass tacks. Why are we here? What are you asking me to do? And why should I do it in your favor? And it's just like very surprising to see it was surprising to see a lot of times how much attorneys just did not pick up on that.
Yeah.
And, I mean, even in the writing, it's like there was a judge, not one that I worked for, but there was a judge who said that every time something was filed, there was a page limit and he would turn to the last page and see if they hit the page limit. And he would always, and that would just kind of like influence a little bit like, okay, so essentially like they're just like, seems like they're just writing to write sometimes. And, obviously that's not always the case, but he just found that when something was shorter and not necessarily all the way to the page limit, if it didn't need to be, that was the better
short
argument.
To the point.
Yeah, be succinct.
Yeah.
Right. That's so important with making oral arguments, I've always found, because the truth is, especially with what we do, whether it's with injunctions or with criminal cases, the judge is not the whole background story is not what's important. to the judge usually. And what we need is whatever we're coming before the court to ask for, we need to get to the point as quickly as possible. And being able to do that, whether it's a quick reset hearing or a long motion hearing, the getting to the point is something you never want a judge looking at you and saying, can you get to the point at this point? I think with motions, I've always tried to keep it as succinct as possible. And that's for two reasons. One, I'm not a great writer.
Yeah, I was like, that's because you're a trial lawyer.
Right. And two, because I'm a trial lawyer. Right. That's exactly right. So, but for the good writers out there, because I imagine there are a lot of our listeners are good writers,
I'm
like,
sure Lauren's a
like
great
our
writer.
guests. Right. It's about getting to the point.
Yeah.
However long that takes you, it takes you, but get to the point.
Yeah. It's like that quote, like if I had more time, I would have written a shorter letter. It's like you need to distill, you need to wade through all the BS, distill down what the important issues and facts are, and just put that down.
Yeah.
It's so crazy that attorneys have that problem because obviously like lawyers love to hear themselves talk. And like, I don't know. That's the other thing is like seeing people in court and they're just like, they don't know when to shut up. Like, did you see that a lot? I feel like you probably did, where you were like,
yeah, definitely.
You're probably hurting your case at this point.
Yeah, exactly.
Yeah.
Because sometimes it's, I forget, there's a local judge who says this, that attorneys get in trouble from what happens between their nose and their chin, meaning their mouth, and it's because they don't know when to stop talking. They don't know when to sit down and just not continue arguing, because you might have made a good argument that the judge was going to rule in your favor, and then you kept talking.
Right.
It's so beneficial watching hearings and seeing that, because like I wasn't a clerk and just waiting for my case to be called. Sometimes I see things like that go down and I'm just like, dude, you just dug yourself a deeper hole. Like, as the lawyer, not the criminal defendant.
It's also about knowing, it's also really, really important to try to know who your judge is.
Yeah.
We get the benefit of practicing in front of a lot of the same judges over and over and over again. So we know, body language and tics that if we go to a certain point with a judge, the judge is like, eyes are glazing over, or they're looking to sign an order that was just passed. Like they're not paying attention anymore.
I know.
We know when that happens. You don't want to be in that. You want to be captivating, but to the point. And you got to know who your audience is. If you go to a jurisdiction that you don't often practice in, don't call up your case first.
Yeah.
Sit there, watch a few cases go first, so you can get a sense of exactly how it's done, how the locals do it, how the judge treats them, and what, they say to get in and out. And that's what you do.
Yeah.
You're not there to network with the judge.
No.
So get in and get out, and just say what needs to be to be said. Yeah.
No, it's so important for sure, especially as like litigators, to like know when to shut up. So I guess we can move on to obviously why we have you here today. But before we get there, can you just like share a little bit about how you got into like interested in even like this area of law, or like even getting to know it?
So in college, my major was finance. I was always kind of more business minded. I'm a Virgo, so I'm very like logical. I need the facts. I need,
the data.
Exactly. So I was kind of like focused on business in college, but I did always want to go to law school. And I thought in law school that I was probably going to do like transactional law, do something with businesses like mergers and acquisitions, something along those lines, drafting documents. And then when I did do the clerkship after law school, I kind of was like, I can do this, like I can be a litigator. And I'm just not a confrontational person. I just didn't think I would be good at being in a courtroom and making those arguments against the other side. But being in there and seeing it done, I was like, I can do this. I could definitely be a good litigator. I know what to do. Because it's not like you said, it's not what you see on TV, like being aggressive and just like trying to like sneak something in at the last minute and like surprise the other side. You can't do that, So it's really not about being confrontational. So after, when I finished the clerkships and realized that I'm from here. I'm from Palm Beach County, and but none of my family are attorneys. I don't have anyone in the family who's an attorney or does anything in the law. Right.
Same.
So I was like, where do I start?
Yeah.
Like, how do I even do this? And I just kind of like would watch like with our cases, like which attorneys at which firms, I thought were doing a good job or, giving good presentations or had good writing. And just kind of like ask around too, like during my clerkship, like how's this firm? How's that firm? And that led me to the firm that I started with after my clerkship and where I'm at now still. It was called McCabe Rabon before, and that's when I joined. And it was 3 other attorneys. It's a small boutique firm, but they did business litigation. They did some securities litigation and arbitration, but they also handled the Qui Tam cases, the whistleblower cases, which was a very interesting little niche area that you don't usually see.
Yeah.
And that definitely piqued my interest. And they were also just good lawyers that I saw in front of the judge. And so it was like months before my clerkship was ending. And I was so anal. I was like a year out from the clerkship ending. I was like, I got to be getting a job. Like I need to have a job. I need to be looking. So eventually on LinkedIn, they had a job posting for an attorney. And so I applied.
You were like waiting for it too.
Yeah.
That's so cool.
Yeah. I definitely, it was very kismet. Like it was good timing for sure. And I loved it. And, I love working there. I loved learning from the 2 partners there. And so one of them is now a federal judge. So that happened a couple of years ago. So we had to take his name off the firm. And so when we did that, we got a new partner. And then they asked me if I wanted to become a shareholder and put my name on the firm. And so obviously I couldn't say no.
Yeah, that's awesome.
Yeah.
So how did you get like exposed to like the whistleblower cases? Was it when you were clerking or was it
No.
when you started working there?
It was when I started working at the firm. And so when I started, it was one partner in particular who is the federal judge now. His name is Ryan McCabe, Judge McCabe. And he worked a lot on the whistleblower cases. And he used to be an AUSA. And so he had experience working in the government, working on those cases. And it's something that just interested him. And so when I started there, I got on a couple of those cases with him, and I just dug in. Like I got really interested. They were, especially the first one I worked on. I mean, it was crazy. Like it was a whistleblower who worked at a airbag manufacturing plant. And it was airbags that were going into cars. And so it wasn't a particular vehicle brand or anything, but these were just being sold to different brands, these airbags. And there had been like, there was multiple plants. There had been like explosions and safety issues in some of their plants. And our whistleblower was complaining about it and reporting it and to the company internally, and nobody was doing anything about it. He was like, these are safety concerns, like these are all the quality issues that are in the plants, and nobody was doing anything about it. And he eventually got fired, for his complaining. And he came to us, and, we brought the case. It eventually settled, but, that was one of the first ones. And so I was like, this is crazy. How is this happening? And nobody's doing anything about it.
So in terms of what, I don't know if you can get more into detail about this case, but I'm just, because this is the example that we're talking about, like what was the part where they were actually complaining about the company? Was it that they were not doing anything about the complaints that were being put in about the explosions, or were they doing other things that were like fraudulent?
It was so it was related. It was basically like safety and quality concerns.
Okay.
So a couple events had happened, like the explosion, and then, they put all these like safety measures in place and quality control checks essentially. Mm-hmm. And he was one of those people that was in charge, like, picture him like walking around with a checklist to each plant and saying, okay, does this plant have the proper like fire alarms? Does it have the proper smoke alarms? Does it have the proper like, procedures for everybody to follow so that when all the parts are being put into, I mean, you can imagine it's an airbag. It's meant to explode.
Yeah.
It's meant to go off and to inflate. And so he was going through and just making sure like everything was all up to par and up to the procedures that they were supposed to follow. And they weren't. He found that they weren't, certain safety procedures weren't being followed. There was issues with like there's like a powder that goes into the airbags for it. And there was issues with the powder because that can be considered an explosive.
Wow.
And so he was reporting these things to his management and they were just kind of like,
they're like, shush.
it's okay, like just, it's okay.
Cheaper for them to not do anything about it.
Cheaper for them, faster for them to get their parts out, to get the airbags made, to get them sold to the vehicle companies. So yeah, they didn't want somebody who was actually doing his job.
Well, they do the cost benefit analysis and they see that if they get sued because one worker dies in their plant, it's less money to pay that lawsuit than it is to restructure all of the factories so that way there could be a safe factory and a safe working environment. That's what big companies do. And if there wasn't provisions like this, then there would be no protection. There would be, if there was not the ability for a whistleblower to come forward and, make the complaint and do that, how would change happen, especially with big companies like that?
Yeah, true. I guess for me, when I thought about whistleblower actions, I was always thinking or under the impression that they were like fraudulent things that the company was doing. I didn't know it could be like just like negligent things.
Yeah.
You know what I mean?
Yeah. So this one in particular, it was because the company had to make a certification to the government because the Department of Transportation is involved with the manufacture of the airbags, and they had to make a certification to the government about certain safety procedures that they had in place. And they were essentially falsely certifying that they were following all those procedures. Yeah. And so that is a form of fraud
right.
So that was like the way that it got into the fraud against the government.
Wow. That's so cool. I didn't know that.
I have a personal sort of question about that. Is about these types of cases. Are they contingency-based cases? Is it? Do you take all the cases like a personal injury attorney does on a contingency basis?
All of our whistleblower cases are a contingency basis.
Okay, and then the recovery from that can be, I guess, punitive damages on top of. Or is there a special classification of damages for these types of cases?
So what happens is under the False Claims Act, which is the statute for whistleblowers to bring these cases under, whistleblowers are entitled to receive between 15 and 30% of whatever the government recovers as a result of the fraud. And so these cases, when it's like, SEC fraud and the company is hit with fines, or when it's fraud for Medicare or Medicaid with healthcare, a lot of times those are submitting false claims and false reimbursements for healthcare. And so whatever the government recovers as a result of those investigations, the whistleblower gets under the False Claims Act, between 15 and 30%, but for other whistleblower matters with like other agencies, if it's not filed in court under the False Claims Act, and can still be filed like directly with the SEC or the Department of Transportation or the IRS. So it ranges from 10 to 30%. And then So then our contingency is based on what that whistleblower recovers.
That could be a huge recovery if it hypothetically, thinking of an easy, quick example, if somebody worked for a cigarette company and was the first person to point out how dangerous and bad cigarettes were, and then sued, and there was this multi-billion-dollar lawsuit and settlement, that person that was the whistleblower would be entitled to a significant amount of money. That's
Yeah, there was a case before the one that I talked about that I worked on with the airbags. There was a case before that against Takata, which is a manufacturer of airbags. And that was a big one where same thing. It was a whistleblower who was reporting safety issues, and they got a big recovery from that.
Wow.
Yeah.
Yeah. Wow. That is so, like, I had no idea. I really had no idea that it could be kind of like it is the same. It's still fraud. It just like looks different. I was like, oh, that's like an employment case. That's
Right.
not whistleblowing,
Right.
but, so what we were talking about this before about like when you were saying like the certain cases are under seal. Like, what does under seal mean? Can you just like explain like why that even exists in whistleblower cases?
Mm-hmm. So when a case is filed in court under the False Claims Act, it is filed under seal, and it's under seal for 6 months. And I'm sorry. It's under seal for 60 days. And then the government can get a extension. They can ask for an extension. So just to back up and give you a little bit of background, what happens is a whistleblower can file a claim under the False Claims Act and say, there is being fraud committed against the government here. This company is doing X, Y, and Z, and the government is entitled to this money. So here's all this evidence. I've put it together in a pretty little bow with my attorney, and I'm just handing it to you. And the government then investigates and looks into it to see, okay, is this material? Like, do we really care, essentially? Is this a high enough amount that it's worth it to continue looking at this and to pursue it? And there's other factors that go into it. Like it can't be based on public information. It has to be it has to be something that the whistleblower has unique knowledge about and personal knowledge about. And you have to be specific. You can't just say, I think this company is committing tax fraud. We get a lot of those calls, you know, like, oh, I know this company is committing tax fraud. And we're like, okay, but how do you know that?
So I just know.
Right, exactly.
It came to me at 3 a.m.
You got to be specific. You got to allege the who, what, where, when, like, what is this fraud? And so that's what the government kind of looks at to see, okay, do we have enough here and do we care enough to pursue this? And if they do, the whistleblower is essentially bringing the case on behalf of the government. Qui Tam in Latin means he who brings an action in the name of the king and for himself. So you're bringing it personally, but on behalf of the government. So the government then decides whether to what's called intervene. And so they have to do the investigation first to see if they want to intervene. And that can take a long time. And so they don't, the courts always give them the extensions because the courts know that it takes a long time. Because, they'll have to look at the documents. They need to collect documents themselves. They might send subpoenas to third-party witnesses, to the company itself. They might interview witnesses. They usually interview the whistleblower first and get a little bit more information and make sure that the whistleblower is credible, that they, believe what they're saying, that they have personal knowledge, and that they knew of this fraud because of their experience with the company. And so the extensions will usually be 6 months at a time. And that is 3 extensions, that's 18 months. It's 18 months. I
crazy.
have a case that's 2019.
Oh my God.
And the government's still getting an extension. And it's legitimate. They're investigating it. We know that.
So that's the point. The point is to protect. The point of the seal is to protect the investigation. It is.
It's to protect the investigation for sure, and so that it doesn't become public.
Right.
And I've actually had a situation where our whistleblower, he was reporting to the SEC, and he was reporting fraud, and he told somebody else who had worked at the company, hey, I'm talking to the SEC, like maybe you should reach out to them. And then they did. And then the SEC contacts us as his attorney because you can't do that.
Yeah.
You can't, that would...
it's like compromising the investigation.
Exactly.
Yeah.
Like it's like, similar to criminal cases, the same way that like the police won't,
like shut up.
Talk about the way the police won't talk about a criminal case or give you information because they say it's an open investigation.
Yeah.
So that's the same way the government doesn't want you to break the seal.
You're a witness by bringing the case to the government. In your case, like your client would be the witness, and like you can't do that. You can't like go and talk to other potential witnesses that may come of the investigation. Let the government do their job.
Exactly.
Oh,
That's because we do, we give the government a
who
list.
they know and all those things.
Here's who you should go talk to. So that's not the whistleblower's job to go tell, somebody else to go talk to the government. And so that can affect like the whistleblower award that they get at the end. If it does jeopardize the investigation, it can affect that.
Oh my gosh.
If it stays in civil court, the government's not the prosecuting body. You are you as the lawyer are the prosecuting body on the case, correct?
Well, if the government does intervene, then we are both.
So basically, and that's such a unique situation. So basically, you're almost bringing a prosecutor, or not almost, you're bringing a prosecutor a criminal case, saying, I have this criminal case. We are going forward on it. Do you as the government want to buddy up and go forward on it? And then the government has the option to do that and then do their own case if they want and separately charge them criminally or however else.
Yeah, they can separately charge them criminally. We've had that situation because we only do the civil side of the fraud. But sometimes, we'll file a case. It's a civil case and the government will reach out and say, okay, we want to set an interview with your whistleblower and talk to them. But it won't just be, a civil attorney from the Department of Justice. It'll be a criminal attorney. It'll be someone from the SEC. They bring whoever they want, whoever they think, might pursue something against that defendant. And yeah, they can bring other criminal cases if they want, or other types of cases or matters against those defendants if they want to. Yeah.
If the case goes to trial, if the civil case goes to trial, hypothetically, could you be sitting at counsel table next to, it would be you and government attorneys sitting at the same counsel table?
Hypothetically, yes. We've never gone to trial in any of those cases. They all settle.
Okay.
They don't want to go to trial.
I can imagine
because
so.
they're legit claims.
So.
Yeah. Yeah. But at that point, if the government intervenes, they are the one who has control. They get to decide, okay, is this case going to get dismissed? Like they can decide we want to dismiss this case. The government can decide that. But ultimately they have the control once they intervene. If they don't intervene, the whistleblower can continue the case, but it's kind of like if the government already looked at this and said that there's nothing here, it's hard to continue the case and to keep it going, especially because we're on a contingency. And,
right.
So it is hard to continue those cases, but we've done it in certain situations.
Amazing. It's so interesting because there's never a circumstance where a private individual is the one that's bringing the case. In a regular criminal case, a private individual could go to law enforcement. Law enforcement could start an investigation, but ultimately the decisions to pursue that case are up to law enforcement and then whatever the prosecuting body is. Yeah. And that's where the case goes. And this victim or witness is simply just that, and their input stops at that. Yeah. They're not, it's not like you have a private citizen that's writing motions for the state attorney's office.
No,
it's like it doesn't work like that.
No.
So this is such an interesting cross.
It's like a unique situation.
Yeah.
Well, it's interesting you bring that up because actually right now there's a case pending in the 11th Circuit Court of Appeals where a federal court in Florida ruled that the False Claims Act is unconstitutional for the reason that you're saying is that, because it's essentially a citizen, an individual citizen bringing a case on behalf of the government, and that's unconstitutional because they're essentially acting in, like a prosecutorial role.
I totally get that argument.
Yeah.
But I think the way around that argument, and I think what ultimately will happen, not with my very limited knowledge of hearing this 10 seconds ago, I think ultimately they will probably decide that if the government has the ability to bring a civil case, then there's no difference between them doing that with the assistance of somebody from the public that is a witness or doing it in this format or fashion. They have the ability to go after people civilly for all different sorts of things. Crime, they can go after people civilly for crimes in certain circumstances, certain financial crimes. So I don't see, I think there's a way to beat that argument, but I think it's a good argument.
That's kind of crazy. I'm interested in seeing how that plays out.
Yeah.
How would that affect your job?
I guess it depends on, how much of the statute if it's the entire statute, that area of law goes away. Right. Yeah. So,
but if it's just like the portion of saying that you can't join in on this prosecution, then it probably doesn't affect it much.
Yeah. Essentially, I guess if we if we weren't able to file a case, but just bring it to the government, because we have to, even before we file a case, you have a False Claims Act case, you have to serve the government with what's called a disclosure memo. And so it's essentially the same exact thing as the complaint, but it's the way of informing the government first.
That you're going to be doing this.
Exactly. Informing them of the fraud and saying, we're going to be filing a case. And then you file the case right after that, after you bring the disclosure memo. And so if that statute was ruled unconstitutional, then yeah, I guess it could be a way where you just give the disclosure memo to the government and then the government decides if they want to bring it.
Yeah, and then there's no incentive for the client.
Well, there could still be awards for the whistleblower, I guess.
There would have to be some sort of restitution agreement.
Yeah.
To do that. But I think there'll be a way around this, because I think ultimately the need for a whistleblower outweighs the need,
because then there
has to be a way to
incentivize whistleblowers to come out.
So that way, huge companies can't get away with, whether that's a fraud or a safety thing, they can't get away with that.
Yeah.
Right.
There has to be a mechanism for it to be, because it's not, you can't just go to HR and report something. Because
usually
the bigger
it
the
sounds
company,
like they usually have tried.
No, right. In these circumstances, that's where you're trying, but it's not going anywhere.
Yeah, they don't do anything about it.
So going to HR is not doing anything, because the bottom line is, when you go to the C-suites and you're talking to the CEOs and the people that run everything, they know what the cost-benefit analysis is for a lawsuit that comes in for the thing that they're doing wrong versus what they're doing right.
Yeah.
I'm not talking about fraud cases. I'm talking more like in the safety example.
Yeah.
In the fraud cases, they know they got way more to lose because they're doing something they shouldn't be doing. So there's no reason to acquiesce to the person that's bringing it to their attention.
Yeah.
And this administration, with President Trump, has been very active about pursuing the False Claims Act violations and, recovering money for fraud. I think it was yesterday, Vice President Vance, he said that for Ohio, that they're pausing Medicaid funding to Ohio because of investigations into Medicaid fraud, which is, I think it's like $1 billion that they're freezing. So, and it's like, and he said the government is generous with their money, which is true when it comes to Medicare and Medicaid. Yeah. I mean, they're paying billions of dollars to states and to like hospitals and doctors directly for this healthcare. And it's almost impossible for them to catch all of it, because then they submit the claims to the government. The government decides whether it's reimbursable and they should pay it back. But I mean, the government is only so big. They miss stuff. They don't know if a company is lying to them about something. So it's big money, and it's a big deal. And so this administration has been really pursuing that a lot and focusing on it. So
they prioritized fraud and going after fraud in different areas and different ways. And one of the big things that you're seeing is healthcare industry fraud, education-based fraud, fraud when it comes to centers for children and like preschools and daycares and things like that. And this is all over the country. We saw a big spike in Minnesota, and everything was happening in Minnesota, it seemed like, but the fraud investigations are big in other states. And whether it's hospice fraud in California or fraud in different sects in New York, like there's different things, there's different types of fraud that it seems like was not something that was uncovered earlier and now has come to light. There's a lot of, a whistleblower is somebody that works on the inside of the company and tries to bring light to the subject. And then you have a muckraker who is a reporter or a person that is trying to do that from the outside of a company where they make a big issue public. And now with all of the, new types of journalists online and social media, you have people that are trying to expose fraud all over the country. And, there's good parts of that and bad parts of that. Obviously, getting rid of fraud is good, and saving the government money is good. but it exposes full communities. It exposes people that maybe got caught up in a bad situation. I mean, I think we'll see cases coming down the line, and I see certain fraud types of cases that we get, just in state level. But that's a big trending topic right now. And when you make the decision to cut off Medicaid or Medicare to a state, that's a huge decision, because yes, you're punishing the government for them the local government for them not taking accountability for the fraud or for doing something to intervene, but you're also punishing the individual that necessarily needs or relies on that Medicaid or that fraud, that Medicare. So it's a double-edged sword, and it's a very severe, probably the most severe sanction, but you gotta cut the fraud out.
Yeah.
However, you got to figure out how to do that. So,
jeez.
Yeah.
I'm like, that is crazy. I had no idea that they did that. But I was thinking, because I was like, the example you gave with the friend, like, your client going to talk to a coworker, does it? I imagine the way these things come to life is that things are going on internally at someone's work, and people are already talking to each other before they even come and hire a lawyer. And so, like, how do you make sure that you kind of cut that off after they like leave your office and you're like, okay, yeah, we have a case here, and like now you need to shut up. And I know you've talked to like all these people, because obviously you know that they have some sort of knowledge, right? So like, how do you cut that off? Like, how do you make sure your clients like don't go yapping?
Are they fired generally? Are the people that come to you usually fired from the company?
They are usually eventually fired, not necessarily when they come to us. So when they come to us, a lot of times they do still work at the company, and it's just that they've reported to management. Management has done nothing or told them to just keep their mouth shut and their head down and keep going and ignore it. So they'll come to us and say, hey, this is going on. I think this is fraud. And so we'll say, okay, yes, this is fraud, and look into it. And if we take the case, I mean, it's hard. Like, of course, we explain it to them, and we say that you can't tell anybody about that. You can't tell anyone that you're talking to an attorney. You can't tell anybody that you're talking to the government. Usually what gets it in their head is we say, if you talk to anybody about this and they file a whistleblower case first, they're going to get the money, not you. So, because there's what's called the first to file rule. Yeah. So you have to be the first one to report this to the government, to report this fraud to the government. And if you're not, you don't get an award. You can still be a whistleblower, but you won't get an award. I've had cases where there's multiple whistleblowers who filed similar cases, and the government will eventually say, okay, hey, you weren't the first to file, but this person was, so you can talk to them and see if you all can come to an agreement about splitting any type of award. And so then at that point, you split the award. Oh. Because some people might, some whistleblowers might have different types of documents. Like, it's the same fraud, but, this person has the financials and this person has the emails or something.
I was just going to ask that. So one of the things that must be complicated is if your client comes to you and they've already been fired, how do they get access to the evidence that they need to prove the whistleblower, unless they collected it themselves over time and then they have it? It's not like you can go back and log into their old system and get the shit they need. So how does...
Yeah, because you can't do that. Even if they tried to do that, that would be illegal.
Correct. Right.
And that would be a whole set of other... criminal violations, but they've usually gathered evidence beforehand. And if they haven't, then we
can't bring the case.
Yeah, you need something. Like, under the False Claims Act, it has to be particular. You have to allege specifics. So, you can't just say this is what was going on in the company. You need something. You need to, you kind of need that evidence of what was submitted that was false to the government. Like whether it's Medicaid and Medicare reimbursement claims to the government, or emails about SEC violations or whatever it is. Like, you need something, because if they come to us and they say, I was fired, I don't have this, it's just really hard to then try to convince the government, okay, you need to do something about this.
Right.
It sounds like it would be like if I'm the person reporting something to HR, it's like, oh, I'm bringing this to your attention because I noticed there was a safety violation during my evaluation on this date, and these are the like attachments of like whatever.
Yeah.
And if they document that and save that, you know, and the email response saying like, shut up, don't mention this to anybody, you know, that usually kickstarts
You got some
something.
stuff, yeah.
Yeah. And usually, because whistleblowers are usually like, just to be a whistleblower, you have to be somebody who questions things.
Yeah.
You can't be someone who just like follows the herd and, you know, like just kind of does what they're told and keeps their head down. It's usually people who are questioners and who are like, you know, a little bit of a conspiracy theorist or maybe a little paranoid, but they ask questions and, you know, they don't stop. So they're persistent. And so when they do make those complaints and get weird responses or they're ignored,
like
they
a red
usually
flag.
keep those documents. Like that type of person like kind of knows, okay, something's going on here. I need to document this and keep it. And so they usually do.
Wow. Is there usually a fear of retaliation on their part when they come to you if they're still employed by that company?
Yeah, like always. You know, there's always a fear that they're going to get fired, but then there's also usually a fear that their company is going to not only fire them but go to other companies
And
in the industry
blacklist them,
exactly and say,
Does that
hey,
happen?
Oh yeah, it definitely happens because it's like
That's why they need to get a big recovery in that settlement because they ain't getting another job.
Exactly.
Who's going to hire a whistleblower?
Right.
Yikes.
Yeah. And then not just that, but I've had some that come to me and say, I am afraid for my physical safety and my family's because, you know, I don't know what they're going to do or like their family has connections to the mob or something. You know, it's like I never know if it's true, but a lot of them fear for their safety too, not just like their jobs and their careers.
Yeah.
So
Wow.
they're really coming to you in a time where they're very scared and they don't know what to do. They don't know who else to turn to. And so they try to ask you to see if it's something that, you know, legally they can do something about because every other avenue hasn't worked.
Oh,
By the time the company finds out that this is happening, that this whistleblower action is happening, do they have to know who the individual is?
No.
So it can stay, could it hypothetically stay confidential throughout the entire thing if the case ends in a settlement and they never find out who the employee was that did that?
Throughout the case, it would. But at the end of the case, if it settles, then they will usually find out, you know, who the whistleblower is. A lot of times before that, though, they know. Like they know
Based on the email says so-and-so's
Exactly.
right. There's easy ways to figure out who it is. Right. I get that.
Or they know this person
It's
was
the only
complaining
person. Right.
about this issue
Right.
and now, you know, there's an investigation. So they usually know. And that's why they're usually fired while we, you know, like in the middle of us either investigating or bringing the case. And then we add a retaliation claim.
yeah.
That's what I was going to say. What do you do at that point?
Yeah. Yeah, you add the retaliation claim because there's laws against retaliating for whistleblowing, obviously. But then there's other like ways that there was a case where our whistleblower, he still had the job, then he did get terminated during our case, and they put a severance agreement in front of him, and they said, we want you to sign this severance agreement. We're going to pay you like $200,000 for severance, but you got to sign this agreement. And it said in the agreement, you know, you can't go to the government. You can't, you know, essentially.
Like an NDA.
Yeah, exactly. A confidentiality agreement that you can't talk to anybody about any like violations that you've seen here, essentially. And that's illegal too.
I was going to say that's illegal.
Yeah.
Right? Yeah.
Yeah, they can't keep somebody from sharing confidential information with the government in order to prosecute fraud, criminal matters, whatever it might be. I mean, they can't just take the confidential information and like go show it to anybody. It has to be to the government because of a legitimate concern about, you know, certain violations. But yeah, the company can't force them to not
That's
tell
like
the
it's like a
government.
form of witness tampering.
Exactly. And like intimidation and
What's going
extortion.
on? Yeah,
It's like we're not going to pay you this $200,000 severance unless you agree to this.
And did they consult with you before they signed that?
Oh yeah. Yeah. So we went back and forth. We like had to hire an employment attorney then to like negotiate so that the company didn't like look like we didn't want to be the law firm negotiating.
The face of it, right.
Exactly. Because then they'd look at our website and see these people do whistleblowing, you know?
Yeah.
So we had to go out and get a different like employment attorney
my
to
gosh.
negotiate it. And yeah.
That
the
is
whole
so
thing.
crazy. There's like so many crossovers.
Mm-hmm.
What is the most bizarre whistleblowing case you've had?
Okay, bizarre as far as
Like weird facts.
grossed me out.
No, I was thinking. Okay,
Sure.
sure. I wasn't
Sure.
thinking. I really wasn't thinking
Just
that.
based
but
on the reaction
yeah.
you just had
I'm
when you said that,
okay,
yeah.
let's do it.
So I would say it's one that's still pending. So like I can't get too much into the facts, but it's a Medicare and Medicaid fraud case where a doctor's office is reusing a single-use product. So to just analogize it,
That's nasty.
you know,
Like, I don't want to go anywhere that's gonna treat me now. I'm like,
when you go to the doctor, you know, like
I
if they put a thermometer in your mouth, these aren't the
Yeah,
facts.
you're just giving an
I'm just
example.
giving an example. When they put a thermometer in your mouth, you know, they put the plastic
plastic on
thing.
it, yeah.
Right. So imagine they're using that in you, but then not changing out that plastic sleeve and using it on you.
Yes, I
then
understand.
Brandon.
I understand.
And then Monica, you're right. And they're not getting rid of those. But they're telling the government that they are getting rid of those and that they need reimbursement for all those little plastic pieces that they're reusing every single time. So that
like,
one.
you better get them, Lauren. You better get them.
That's so
I'm
gross.
so mad. I'm like, I can't believe that. That's
Yeah.
so bad.
Yeah.
That's really bad. And you're also like violating, like, just as like physicians or caretakers, like your oath as like you are actively sharing whether it's germs or like it could be like blood or whatever, like whatever it is you're doing, like that is obviously like that procedure's in place for safety concerns and health concerns. So like
100%, yes.
what?
I knew that cotton swab tasted weird.
Oh my God, stop. I'm like, I hate this so much. That like is gonna haunt me at night. I'm gonna like have a nightmare tonight. Be like, oh my God. Be like, I can't go to the doctor anymore. Be like, show me that you switched it out. That's funny.
Just tell me who your doctor is. I'll tell you whether you're getting that.
Yeah, you'll be like, you're good.
I went to my dentist yesterday to pick up my Invisalign retainers. Thankfully, they fit me so well. Otherwise, I'd be worried.
Oh my God. You'd be like, why are these loose?
I'm sorry, these are not my teeth.
Yeah.
At least with that, they couldn't do. They have to only make one. They couldn't be using that on everybody.
Yeah.
But geez, that is so gross.
Nasty.
Yeah.
Wow.
So, okay, I was, so what about like the strangest set of facts? Like something that you were like, because I was really thinking like, I don't know, but that's really, I mean, that's a good one.
Do you have any interaction with like Ponzi schemes?
No, I have not personally worked on any of those cases. I've worked on some other securities cases where it's like we have a civil case and then the government brings kind of like a parallel investigation case based on the same type of facts and situation, where it's like investment and securities fraud, but not a Ponzi scheme.
Okay. Anything where like the typical example where there's like an accountant comes to you and is like the CEO is stealing money from the company?
Oh yeah, there's a ton of people that come to us with situations like that. The issue with those though is that so there's different types of whistleblowers. So one type of whistleblower is whistleblowing against the like essentially whistleblowing for consumer fraud. So like you're saying, like maybe like fraud against the company itself or fraud against consumers because, you know, something isn't like the Boeing whistleblower, right? Where it was they were saying that there's these safety concerns
Right.
and these planes are going out and they're not meeting the standards.
Yeah.
But that crosses over to you too, because the government agency that regulates travel has got to
Sure. Yeah.
sign off on airplanes being safe and things like that.
Right. It definitely can. And there was a False Claims Act case that was filed that was related to the Boeing whistleblower too. But when it's just purely consumer fraud, like education fraud, like you were saying, if it's like against the student, you know, where they're saying that the university is like, you know, somehow like they paid for extra classes and they're not being reimbursed, like things like that, like smaller matters. That's what those kind of are. And we don't do those. We only do the fraud against the government portion.
Got it.
So that's the Qui Tam. That's one of the other ones. It's whistleblowing for fraud against the government. And that can be, like I said, the false billing, seeking reimbursement when you're not entitled to it. It can be false certifications to the government. But then there's also the government whistleblowers where, like Edward Snowden, he was leaking the documents of the NSA, and he got in trouble for that. But he was a whistleblower against the government itself. So there's different types of whistleblowing, but we only do the fraud against the government. Our firm does.
Wow.
Got it.
That's so cool. I feel like I'm learning so much today.
Good.
I hope our listeners are too. So considering we're in Palm Beach County, I should say.
Yeah.
We're on the west
You just
side.
keep us off the
west side
island
of the
ever since we
bridge.
did the Epstein series.
I know.
You just make
Well,
sure we stay off
Going
the island.
over to the island. I guess, I don't want to, because I know there's, certain things you can't really say. So I don't want to ask, oh, do you guys...
You have a case that came off the island?
Yeah,
Is that what you're trying
basically,
to say?
yeah. I'm like, anything over there?
We've definitely had clients, who live over there or who are suing each other over there on the island. And it's funny because those cases are so petty.
Yeah.
Those are the
I can
pettiest
only imagine.
cases.
Yeah.
It's like this neighbor's bush is too high and they won't cut it. Now it's blocking my view.
Yeah.
Or a friend got another friend to invest in a company and it tanked. They lost their investment. That was like $1 million. And now they're going to sue and they're going to get their money back and they don't want to settle for, half that amount, quarter that amount,
They're
whatever.
spending more in attorney's fees.
Exactly.
That's so ridiculous.
And they don't care. They don't care. They're like,
They're
yeah, I know.
have to win. Get me a verdict for it that says that
Yeah.
I am the winner.
That's right.
That's what it's like dealing with very wealthy people, I feel.
Well, we get petty injunction cases sometimes when it's neighbor disputes.
Oh,
or at least me. I've had two back-to-back where it's been just neighbor disputes and they it gets a little bit more than, somebody hits somebody or somebody sprays somebody with water or somebody's making noise over the fence at the middle of the night. It's it's random facts that lead to and just pettiness that leads to actions being brought.
True. People are just petty.
We see it.
Yeah.
I was talking to somebody the other day that I think there's a
Yeah.
big increase in neighbors fighting and neighbor disputes lately.
Yeah.
I don't know what it is, but
Politics.
Actually, yes, in part.
Literally.
Yeah.
That is in part what it was. Well, one of my cases that was, the other one that had nothing to do with politics, but one of my cases there was some political crap in it. And yeah.
People don't know how to have conversations anymore.
Well,
It's okay. Keeps us in business.
That's true. That's very true.
For sure.
I'm like, this is
All
how
of
we
us.
make this is how we make
Yeah.
our money.
Yeah.
So
Monica's like, let them fight.
Yeah. Then call us. When it comes to dealing with government agencies, and obviously the False Claims Act
Yes.
is a federal
Yes.
law. So you're always dealing with federal agencies for the
Not
most part.
always. There are state whistleblower acts. There's a Florida Whistleblower Act, and we have brought a couple cases, or we'll bring it under both. We might bring it under the False Claims Act and under the Florida Whistleblower Act. So we have had different Florida state whistleblower cases. But again, those are a little bit hard because sometimes it's just not enough for the government to say that they care and that they want to do something about it.
Do you notice if there's something specific that makes them say that, or it's just based off their review of whatever you give them?
Usually it's the amount at issue. There was one that we brought to the state government and said that you're owed this amount under you have this contract. The state government has this state contract with a private company. Under the contract, the company owes the state X, X percentage of the amount of sales that you do. And they weren't giving the state government that. And so we had to come up with, our own calculation of this is what the state is probably owed that has not been paid. And I just think it wasn't enough for the government to say, for the state government to say, okay, let's pursue this. And that's the thing too, is that you don't know. The government keeps their investigation totally secret from
That's
the whistleblower. Right. So like, we'll like call and ask for updates and they're like, we can't give you an update. We're still investigating. That's all they'll tell you. We're still investigating. If they look into it and they decide that they're not going to continue to, they will tell you that. They'll say, we're not going to pursue it. We're not going to investigate anymore. But if they're still looking into it, that's all they'll say. They won't tell you who they're talking to, what documents they have. And
they could be going on for years, like we've been saying.
Exactly. Yeah.
Oh my God. I hope your 2019 case ends before 2029 at least. Like we're approaching a decade. I'm like, damn, that's crazy.
Yeah.
So I know we're talking a lot about, we talked about, business litigation. Your firm does business litigation. You only handle the Qui Tam.
No, I do both.
So you do both.
Yeah. I mostly actually do business litigation. And then I also handle the Qui Tam cases. And so does my partner, Adam.
So when it comes to business litigation, what are most of the cases that you deal with? Like, are they usually like business divorces? Are they usually?
A lot of them are business divorces, breach of contract, non-compete agreements. That's been something recently that we've seen a lot of. An employee gets terminated or quits and they had a non-compete agreement or non-disclosure agreement, like a confidentiality agreement or non-solicitation where they're not supposed to like get other customers from that company to come with them or get other people who worked at that company to come with them. And they're, it's alleged that they're violating those terms somehow. So we've done a couple of those cases recently.
So you would usually represent the employee, not the employer?
We do both.
Oh,
yeah.
Okay.
So like in business litigation cases, we are plaintiff or defendant. Usually we're defendant in those cases, or representing the defendant, I should say. But a lot of those too recently have been like violations of the Computer Fraud and Abuse Act, where like if somebody's hacking into somebody's email, that's a civil violation, but also a criminal violation. So, if that has happened, we've defended people against that. Yeah.
Do you see like crossover with criminal law and business litigation?
So we, not with business, like there's definitely times in our civil business cases where I'm like, this is not, this is illegal or this is a crime.
But it's not being actively prosecuted.
Exactly. It's not prosecuted because it's something so small where like, like those computer cases where there's hacking, the prosecutor is not going to, a federal prosecutor is probably not going to go after an individual citizen for hacking into his ex-wife's computer email.
It's not that serious for them.
Yeah. They're not going to prosecute that. So it is a crime technically, but they don't prosecute it. And so that's why we bring the civil case. Yeah. So we definitely see crossovers like that. Or I have cases where somebody has recorded somebody else without their consent, and that is a crime in Florida. If the other party, Florida is what's called a two-party consent state. Mm-hmm. So anybody who is being recorded on, a phone call, a video, needs to consent to that, or at least needs to be told and made aware that the recording is being done. And then that way they have the option to like not be on the phone call or to leave, whatever. And so if they're not aware of that and they're recorded, that's a crime too. But again, usually not really prosecuted.
Yeah.
And there's like obviously exceptions to that where if it's to record a crime or something like that, there can be exceptions. But, it's not admissible. So we'll have clients come to us and have evidence where they say, oh, I have this evidence to prove my case. It's this phone call that I recorded with the other person. And we're like, actually, that's not admissible. We cannot use that.
So I had somebody, same situation happen, and she was the one that was being recorded without her consent. Mm-hmm. And that guy's attorney reached out to her attorney, and she ended up hiring me to represent her as a victim for purposes of being recorded. But ultimately nothing came of it. But same situation. And her attorney went to the other attorney went to her attorney and was like, you owe us money for blah, 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 because of like by using like the audio of the recording to show that she like was in breach of whatever contract. But I was like, this is illegal. Like, how did like this lawyer even think that it would be okay to even supply that to another attorney?
Because like we talked about at the beginning, lawyers are just bold and aggressive
literally.
and, you know, just want to hear themselves talk. And so they'll use the tactics like that to try and intimidate people.
And then she ended up paying him out.
Oh, no.
And then that's why I was like, dude, you should not have done that.
Yeah.
But here we are.
But and that's why they do it, though, because people fall for it and they do that. That's really sad and unfortunate that. And that gives us attorneys a bad name.
That's what I'm saying. Yeah. Well, bad lawyers do give us a bad name.
Yeah.
And even you were saying in the beginning a little bit, because it's funny that you were talking about like you're just going into litigation. You were like, oh, I can do this because you thought it was confrontational. It's just that idea that we get when you're not exposed to the law. You don't have anyone in your family that's a lawyer. That like being a litigator means you're an asshole. You lie. You'll do anything to cut corners and whatever. And like my family, even till now, they don't fully understand like what it is that like litigation means, but like they still like make jokes about it. And I'm like, whatever. But it's just like, if you're not exposed to it and see it, like you really wouldn't know. You're just like, it's the stereotypes of all lawyers, you know?
Exactly.
That you're an asshole and you're whatever, a lying litigator.
Yeah, lying, sneaky. Not all of us.
Yeah. There are some good ones out there.
The ones in this room are pretty good.
Yeah.
Do you have any other?
No, I think we should do some rapid fire questions.
Yeah, I was like, I want to get to rapid fire.
Close it up. All right,
start.
so I'm going to start.
Yeah.
Better liars, executives or criminal defendants?
I think it depends on the type of crime, the type of criminal, like if they're sophisticated. But I do think executives are better manipulators because, you know, they just know how to skirt something or omit something or kind of like dance around the truth instead of like flat out lying. So I think that executives are definitely better manipulators, probably liars too. But yeah.
Good answer.
Most dangerous email opener.
Per my last email.
That's a good one.
That I feel like in like lawyer talk, that's like, come on, you idiot!
Yeah,
look at what I just said.
Yeah. Right. Literally, I'm like, I always try not to say that.
But sometimes people are idiots.
Yeah.
One thing professionals should never put in a text.
Okay, so realistically, a dick pic or nudes.
Okay.
Because I have had a case where a client, so our client got sued by his former business partner and got a judgment entered against him. He didn't pay the judgment. So the other side pursued him, hired an investigation company to like look into his assets and kind of look into all of his stuff. They somehow hacked into his email and his texts, and he had
pictures of
dick pics on there, and they used him against him, and he
can't even say anything.
He sued them for that. I mean, he did he used the Computer Fraud and Abuse Act, and they hacked his email. But it was it was and that case too was wild because throughout the discovery process, obviously we got all the photos.
You're like,
we got the emails,
seen my client's dick,
and the text, and the photos.
We're literally talking about a business contract, and then it's like penis.
Then me being like at the time I was
You're like, I'm such an innocent baby.
I was an associate.
So
I was a younger. This was like I think in like 2019, and so I'm like looking through all of the discovery. I see everything. I see all of this, and then there's like 8 other attorneys on the case just on our side because it was like the guy was super wealthy. So I like go to them and I'm like, you guys, have you I looked at all the
They're like, it's another day.
No, they were like, oh, you looked at it? They were like, we didn't look at it. I'm like, what? I'm like, I'm the only one who has now seen the private areas of our client. Like,
now you have to meet this client.
I know.
I would have been like, you all have to
I'm
look
like,
at
why
it now.
didn't anybody tell me?
That is hilarious.
So it was, So I would say don't put that in your email or text messages.
That is so funny. Yeah, that's true. And people talk too. Like, that's embarrassing.
That's really funny. I like that. I think that's hilarious.
Thankfully, I've never seen any of my clients' dicks.
That's good.
Yes.
You don't want to.
No. Especially in my area. Okay, last one. Biggest red flag in a business dispute.
I would say, like, a lot of clients come to us and say, this is, this is an easy case. Like, we're definitely going to win this case. That kind of like overconfidence.
Yeah.
I'm always like, that's not true. Tell me the truth right now.
Or like oversimplifying everything.
Yeah.
It's like you really don't know how complicated it is, actually.
Yeah. And like, and especially nowadays, like with AI, clients will come to us and say, well, I put this into ChatGPT and it says to make these arguments, so you should make these. And I'm like, that's not how this works.
Yeah.
Actually, first of all, it's not even using Florida law. Second of all, did you give it all the facts? It's just, it doesn't work that way. But it's like that overconfidence and oversimplification, I think, is like a big red flag, like in kind of evaluating cases and seeing whether you're going to accept it or not.
Oh my gosh.
Because you just know that if the client's like that at the beginning, then during
it's
the
kind
case,
of a red flag. Yeah.
It's a red flag. There's going to be stuff that comes out during the case that you weren't expecting, that they didn't tell you. It's, that from the beginning that they're not probably going to be truthful. They're going to manipulate you or try to.
Jeez. Honestly,
good to know.
We're like, we don't really deal with sophisticated people very often.
Some of my clients are sophisticated. They just drank too much.
They weren't sophisticated when they drank too much.
Well, fair enough.
Well, Lauren, thank you so much. I'm so happy you came and told us like all these great stories and we learned more about you. So I'm just happy that you came and joined us.
Thanks for having me. This is really fun.
Yeah. We told you it would be a fun time.
Yeah, it was a good time.
So if you liked listening to the show, make sure you like, comment, and subscribe. We're on all platforms. Come back with a warrant.pod. Give us a 5-star review and make sure you subscribe to our newsletter. And if you don't like listening to us,
come back with a warrant.
I just bought a new automobile the same way they did in the 1900s when movies were silent.
Well, I just got this Jeep from FlexCar. Maintenance and insurance are included, and I can switch cars anytime.
What are you, high on giggle juice?
The first and only month-to-month car lease. FlexCar, you drive everything.